Okay, Thomas Freed here, author of Simple Truth About Income Tax and the American Tax Bible, and webmaster of the tax-freedom.com website and the irszoom.com website, and now the producer of the Tax-Freedom channel at YouTube, at Tax Freedom, and taxfreedom.com is the website where this is all written up. And what I'm going to do is run through the income tax laws and the power to tax income that has been misenforced and maladministered, to say the least, by the federal government for, well, since World War II, 80 years. So why don't we start? The Constitution provides for the federal government to tax under two major categories of taxation, which historically have been referred to as direct and indirect. Direct taxes, we're going to look at first, are taxes on property or persons that cannot be avoided and for which the burden cannot be shifted to some other party. So that's like $100 a head on a tax on people, or $10 an acre on a tax on property. And while the federal government has the power to do that, they don't have the power to ask individual citizens to pay the tax on their property or on their head. The direct tax is apportioned to the state. That's what Article 1, Section 2, Clause 3 says. Representatives and direct taxes shall be apportioned among the several states, which may be included in the Union, according to their respective numbers under the last census. So what that means is if the federal government wants to raise $100 billion by a direct tax, and the first thing you have to do with a direct tax is specify the amount of money that is to be raised by the tax, because if you don't specify how much you're raising, you can't apportion the amounts to the states. You can't send the state a bill for 10%. I think 10% of what? Now you need to have the $100 billion, the amount to be raised by the direct tax, hypothetically speaking here. You need the census, and if, hypothetically speaking, the census showed in the last count, even if it was 10 years ago or 9.5 years ago, that the amount, the percentage of the population that lived in California was 10%, well, then California would get a bill for 10% of the $100 billion in total being raised. So California would get a bill for $10 billion. Wyoming might get a bill for $1 billion, having just 1% under the census, hypothetically. So when every state pays its share, the U.S. government, the central government, gets 100% of the direct tax paid by the states, but it can never show up on the doorstep of the people asking them to pay a direct tax. Article 1, Section 2, Clause 3 further restricts the power to tax directly by saying no capitation or other direct tax shall be laid unless in proportion to the census. So this means that the only way they can lay a direct tax is to give each state its proportionate share of the bill. But if a specified number isn't being raised, it isn't a direct tax. And specifically, direct taxes are usually one-time events. They're not continuous or repeating without additional legislative act from Congress. So direct taxes are taxes on persons and property that cannot be avoided and for which the burden cannot be shifted. So if the government ever tried to tax you and the burden couldn't be shifted, that would be unconstitutionally direct tax. Okay, indirect taxation. The Constitution authorizes the federal government to tax indirectly. The Congress shall have power to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and general welfare of the United States, but all duties, imposts, and excises shall be uniform. Okay? Now, the apportionment clause on direct taxation is the limitation applicable to direct taxes. They have to be apportioned. This uniformity requirement is the limitation on indirect taxes. You have to tax uniformly, meaning everybody has to be treated the same. Duties are the power to tax foreign persons, foreign activity, foreign imports, and in foreign places where the government is the territorial authority and where it's technically not part of the United States. Places like territories and possessions. Duties could apply in territories and possessions. Imposts, oh no, I'm sorry. Oh, good grief. Imposts are the authority to tax foreign persons, foreign activity, foreign places. Duties are the power to tax exported goods for being taken out of the country for consumption or sale in foreign markets. That's why we have duty-free shops on the other side of the security checkpoint, but only in the international terminal. To get through the security checkpoint, you have to have a ticket. If you have a ticket, you're leaving the country. If you're leaving the country from the international airport, you can shop at the duty-free shop tax-free. Now, duties are taxes only on goods being exported from the country. And America has pretty much foregone taxation by duty because we don't have any natural resources or production problems where the government feels we need to keep those things in the country. We don't punish our manufacturers and producers for successfully selling into foreign markets. We encourage it. Impost, the power to tax foreign activity, foreign persons, foreign imports, and in foreign places, like in foreign countries under tax treaty and in territories and possessions. Excises, the Supreme Court ruled in 1911 in Flint v. Stone Tracy, 220 U.S. 107. Excise, the power to tax by excise, is the power to tax the manufacture, consumption, and sale of commodities within the country, things like ATF, alcohol, tobacco, and firearms. It's the power to tax licenses to pursue certain occupations, like a license to sell, ATF. And it's the power to tax the corporate privilege, where it is the privilege that is the subject of the tax, and income becomes the yardstick that measures the amount of tax owed on the earnings derived from the taxable activity which occurs under the privilege. If the privilege is a license for alcohol, tobacco, and firearm, you only have to pay income tax on the income derived from the license. If you're a corporation, you have to pay tax on everything because the privilege is the privilege of incorporation, and all of your earnings are derived from within that enjoyed privilege. Citizens, however, don't work or earn money as a function of privilege. They have a right to work, and the fruits of labor are not subject to any duty, impost, or excise. Exported goods, foreign persons and activity, corporate persons and activity, and licenses. So you see the problem, right? Well, we're going to get to it. Now, all of these powers to act that are given to Congress to tax directly and indirectly by duty, impost, and excise, in order for our federal courts to be able to take subject matter jurisdiction over a claim brought to the court by the federal government, the court needs to be shown by the plaintiff, the United States, that the power allegedly exercised has been given to Congress with respect to the power exercised to write law to enforce the power. All of the original taxing powers of the Constitution are made authorized at law by a constitutionally authorized Congress to write law. They're constitutionally authorized to write law by Article 1, Section 8, Clause 18, which is the original necessary and proper enabling enforcement clause. It is this enabling enforcement clause that constitutionally authorizes Congress to write law, which is necessary to show has been done in order for any federal court to take subject matter jurisdiction to enforce the statute brought to the court. They have to know that Congress was constitutionally authorized to enforce that law or that power through statutes that it was authorized to write. If you can't show that statutes were authorized to be written by Congress with respect to any taxing power alleged exercised, the court can't help the government with the claim. They don't have subject matter jurisdiction. Congress wasn't authorized to write the law by an enabling enforcement clause. It isn't there. in the 16th Amendment, which you're going to get to, which is a critical problem for the government. We're going to see. But all of the original taxing powers, which didn't include any power to tax labor or income or earnings of the people or the right to work, it isn't here. It isn't here. The original Constitution doesn't give that power. No such tax was ever applied or imposed previous to the 1900s. So again, constitutional authority for the enforcement of the taxing powers comes out of the necessary and proper enabling enforcement clause. These are the only taxing powers in the Constitution made enforceable at law by a constitutionally authorized Congress who is constitutionally authorized to write law to enforce these powers. Direct taxation, which has been apportioned, indirect taxation by impost, duty, and excise, which is uniform. Okay, so again, the subject matter jurisdiction in the United States courts requires 3 elements to exist. Now, this is lost knowledge. Pay real close attention here. This is lost knowledge to the American people. Constitution requires 3, subject matter jurisdiction requires 3 elements to exist. 1, the power, the U.S. Constitution must grant a specific power to tax for Congress to exercise. You know, like impost, duty, or excise. The U.S. Constitution, 2, the U.S. Constitution must provide an enabling enforcement clause for Congress to be authorized to write law to enforce by law the power granted in number 1, the taxing power granted. And 3, the U.S. Congress must actually enact legislation to pass a law imposing and enforcing the specific taxing power granted in 1 above and made enforceable in 2. So power granted, authority to write law for the power, and then they actually wrote the law. 3 legs of the subject matter jurisdictional stool, which must be assembled in the courtroom by the plaintiff for the court in order for the plaintiff to have standing before the court to step up onto the platform created by the 3 legs of the subject matter jurisdiction and be able to ask the court to assist the plaintiff with enforcing against the defendant the taxing power alleged brought to bear and argued. If any of the 3 elements are missing, the court doesn't have subject matter jurisdiction. The power to tax alleged exercised hasn't been granted. The court doesn't have jurisdiction. If the power to allege to tax hasn't been made enforceable at law by a constitutionally authorized Congress through the presence of an enabling enforcement clause that applies to the specific power alleged, granted, and exercised in operational practice, if they're not authorized to write law, and it can't be shown that they are authorized, subject matter jurisdiction is missing. And if Congress didn't write the law or write a law to implement the power granted and made enforceable, then the court can't help them. And the perfect example of that is what happened with the LSD laws in the early 60s. The federal government went to court arguing LSD violated the Schedule I controlled substances and everybody doing it should go to prison. And the court said dismissed with prejudice for lack of subject matter jurisdiction. Congress never put LSD on the Schedule I list. They're asking us to enforce a law that doesn't exist. We kind of agree with you that it should be a controlled substance, but until Congress makes it one, dismissed with prejudice. Case was over. So, there you have it. The Congress shall have power to lay and collect taxes, duties, imposts, and excises. But that language, shall have power to lay and collect taxes, wasn't sufficient. It needed the enabling enforcement clause to actually empower Congress constitutionally to write law to enforce the taxes. Okay, so before the 16th Amendment, we have the jurisdiction of the federal courts to tax indirectly. And here you can see it. They had the powers, they had the indirect power. indirect powers, direct taxes don't touch the American people. So we're talking about charting taxing power that impacts the American persons individually. We can leave direct taxation out of it. Those taxes bills have to be presented to the states, and they don't go to the people. Whether or not the people will be impacted by what the state does is a different discussion, but purely hypothetical. So indirect powers are the only powers that can touch the American people. They're granted under Article 1, Section 8, Clause 1, but only in the form of impost on foreigners or imports, on duties on exported goods, and on excises, which are on commodities, corporations, licenses, tax collections, other indirect, as I said, alcohol, tobacco, firearms, commodities, licenses, and corporate activity. But surprise, right? None of these powers reach the people. We, the people, aren't touched directly unless we're dealing with a foreigner or importing goods. If we're exporting goods, we're still not touched, but we could be if in the future Congress writes a law. And if we're acting as an individual instead of a corporation, we're not touched by the excise taxing power. And there's actually a statute that says that. Title 15, Code Section 17 says the labor of a human being is not a commodity or article of commerce. And that statute specifically removes the labors of the American people from excise taxation, which only applies to commodities and articles of commerce, other than the corporate person or the licensed person. So, all income derived from these taxable activities is constitutionally taxable to the federal government, and it was so before the 16th Amendment. So the question becomes, well, here are the powers. None of them touch citizens. They're all made enforceable at law under the Article 1, Section 8, Clause 18, Necessary and Proper Enforcement Clause. But none of these enforceable indirect taxes touch we, the people's right to work. So outside of alcohol, tobacco, and firearms, petroleum fuels, other taxable commodities, the federal courts don't have personal jurisdiction over the citizens because they're not part of these taxable activities. They have subject matter jurisdiction over the impost, the duty, of their excise, but you can't show personal jurisdiction that brings the citizen into this box just based on a function of labor. So previous to the 16th Amendment, there was no authority whatsoever to tax the labors or the earnings of the American people derived from the simple exercise of the right to work. No personal jurisdiction existed for the federal courts to enforce under Article 1 an indirect income tax on the wages derived from the simple exercise of the American citizen's right to work, because the taxation of wages is not part of the indirect taxing power. And this is why they needed to enact the 16th Amendment. And there's a story behind that, but we're not going to get into court cases today. This goes back to Pollock v. Farmers Loan and Trust in 1896, where the court said you can't tax sources streaming from property because of the source tax that makes it a direct tax. And that meant they couldn't tax earnings streaming from property or earnings streaming from persons. It kind of prohibited them, and the Fabians, the early part of the century, went all wacko and spent 20 years after that decision trying to get the 16th Amendment enacted. So here we go. 16th Amendment to the Constitution, 1913. Congress shall have power to lay and collect taxes on incomes from whatever source derived, without apportionment among the several states and without regard to any census or enumeration. Does that do anything new? Well, if it does anything new, where's the enabling enforcement clause to authorize Congress to write law for the courts to take subject matter jurisdiction under anything claimed to be sourced from authority created by the 16th Amendment? It isn't there. This can't possibly do anything. And this is why for 100 years people have believed the tax is voluntary. Because if you tell me I owe it because of the 16th Amendment, I know for a fact as a student of the Constitution that there's no enabling enforcement clause. Congress isn't authorized to write law. If the court can't show that Congress is authorized to write law, It can't help the plaintiff. There's no authority to write law, therefore it has to be voluntary. It can't be mandatory. No one's authorized to write law. All the other amendments have their own enabling enforcement clause. The 13th, the 14th, the 15th. And then amendments after the 16th have an enabling enforcement clause. So you can't argue this created a precedent where it was no longer necessary. No, it's still necessary, and they did it. For all the other amendments where it would be enforced against the people, women voting, 18-year-olds voting, they all have their own enabling enforcement clause. And the amendment, does it contain the word direct? Congress shall have power to lay and collect taxes on incomes from whatever source derived without apportionment among the seven without regard to it. No, it doesn't say it's direct. And here's the same language from Article 1, Section 8, Clause 1, lay and collect, which was insufficient in Article 1. It needed the original necessary and proper enabling enforcement clause to give Congress the actual power to write law to lay and collect. So where's the power? Where's the authority for Congress to write law? Where's the enabling enforcement clause? It's missing. So this explains the two great myths in American history about the federal income tax, doesn't it? If you start up here with Article 1, there is no law. There's no taxing power that reaches the American people's labor with legal effect. There is no law. If you start with Article 1 as your claim source of authority, there is no law. If you start with the 16th Amendment as your claim source of authority, it has to be voluntary because Congress isn't constitutionally authorized to write law under the amendment. Subject matter jurisdiction doesn't exist under this alleged source of authority. Doesn't exist. This is irrefutable proof that there's a problem with the income. And remember, we needed a power to tax, an authority to write law. The power to tax isn't granted. Direct isn't here. If you read this as allowing a direct tax without apportionment, you're using the 16th Amendment to create an irreconcilable conflict with the Article 1 provision that says direct taxes must be apportioned. That was not repealed or amended. If they intended for this to be direct, they could have added, and Article 1, Section 2's limitation of apportionment is hereby removed from this particular power. They didn't repeal or amend anything in conjunction with this. They left the word direct out. There's no direct taxing power that's authorized here. And there's no authority to write to enforce it with written law. Well, let's look at what they actually did. What they did in 1913 is they wrote the Underwood-Simmons Tariff Act. You know what a tariff is? Tariff is one form of an impost. Oh, and look what else they did. Isn't this cute? Down here, H, subsection H. Here in section H is the territorial limitation we see made applicable in the original income tax legislation of 1913 that we see in a moment, faithfully implemented the 1939 statutes at large, showing that the subject classes of foreign persons created in sections we're going to see 4D, 4E, 4F, and 4G, they're all foreign. But look at what they do. State or United States, when used in this section, shall be construed to include any territory, Alaska, the District of Columbia, Puerto Rico, and the Philippine Islands. Remember I told you an impost applies to foreign activity in foreign places? And a tariff is one form of an impost, the taxation of foreign activity. And here in the legislation that they passed, the Underwood-Simmons Tariff Act, imposing an impost in foreign places, the territories and possessions. The 50 states aren't included in this definition. This is where it comes from, that it doesn't apply in the 50 states. It's right there in the original act. In 1913, includes was limiting. What the law includes are only the things listed. Not everything not listed, but normally that might be considered to be within the definition. No, law is specific. It's not open-ended. When it lists what's included, that's what's included, the territories and the possessions. It's effective only in the territories and District of Columbia. It's redefined for use within the Act, the United States. This is a special piece of legislation, special legislation over a limited area and limited persons, as we'll see. Now, here it is highlighted. The word state of the United States when used in this section means territory possession. Alaska, Hawaii should be here too. I guess Hawaii became a territory 5 years later in like 1918, right? So they're not even here yet. Okay, now obviously we know that the income tax laws got immediately challenged, and the controlling case, the first two cases on the constitutionality of the income tax, the first one is Bruchaber v. Union Pacific Railroad Company, 240 U.S. 1, 1916. And in this case, well, let's look at the syllabus. The 16th Amendment was obviously intended to simplify the situation and make clear the limitations on the taxing power of Congress, and not to create radical and destructive changes in our Constitution. You see right off the bat, they're rejecting the government's argument. This creates a new power to tax directly and without limitation. They're saying, no, no, no. It simplifies the situation. The 16th Amendment does not purport to confer power to levy income taxes in a generic sense, as that authority was already possessed. Remember, I told you they could do it as part of indirect taxation. That's what the court is saying. Look here. Here's Bruchaber from the court decision on page 9. As a stockholder of the Union Pacific Railroad Company, the appellant filed his bill to enjoin the corporation from complying with the income tax provisions of the Tariff Act of October 3rd, 1913, the Underwood-Simmons Tariff Act. And Bruchaber, Frank Bruchaber, the plaintiff who sued Union Pacific Railroad, he didn't sue them because they were collecting tax from him. He's not the taxpayer, and he's not the tax collector. He's a stockholder. He's a stockholder of the company. And as a stockholder of the company, he has standing to sue the company. He's not the taxpayer. He's a stockholder. What's going on here is Union Pacific Railroad, when the tax was imposed, announced that they intended to comply with the provisions. And Bruchaber, a stockholder in the company, didn't want his company wasting money and time implementing something that the government should be doing on their own without saddling his company with costs. Okay, so this isn't about Bruchaber paying tax. Everybody thinks it's about Bruchaber paying tax. It ain't. His status as a New York citizen is completely irrelevant. His standing in the case is based on being a stockholder. He may have bought one share just to file the suit. Probably not, but he could have. So he's filing the suit to stop the company from voluntarily assuming the costs and administrative burden of administering to the new income tax law. It's a back door to challenging the tax. You can't make my company do this. Okay, and then the court, in analyzing what they're doing in the case, this is where they're stating and laying out what the legislation does, and then they're going to analyze whether or not what it does is legal or not. They point out that this is on page 21 of the Bruchaber decision, the Act provides for collecting the tax at the source. That is, makes it the duty of corporations, etc., to retain and pay the sum of the tax on interest due on bonds and mortgages, unless the owner to whom the interest is payable gives notice that he claims an exemption. Well, wait a minute. Collecting the tax at the source? That's what it's all about. Getting the money before it actually gets paid to someone. Collecting the tax at the source makes the duty of corporations, etc., to retain and pay. This sounds like withholding. This doesn't sound like you pay tax on your own labor. They're collecting the tax at the source is the scheme of taxation, and it makes it the duty of corporations, etc., to retain and pay the sum of that. Well, that isn't what's going on today, unless you look at employers. But you know, employment didn't exist as a term in the law in 1913. The employer didn't exist, the employee didn't exist, employment didn't exist, and the federal government had no authority over employment or employers. That was all strictly a state function, who would never have dared to try tax the labors of the American people in their state, because they would have gotten thrown out of office in the next election. Probably wouldn't have collected much in the meantime. But let's look at what the court said. And this is Stanton v. Baltic Mining right down here. This is the second case. These two cases were taken successively by the Supreme Court. 240 U.S. 1 is Brushaber, 240 U.S. 103 is Stanton. One right after the other. Bang, bang. They decided both cases at the same time consecutively. So they say, by the previous ruling, which is the Brushaber v. Union Pacific Railroad ruling, it was settled that the provisions of the 16th Amendment conferred no new power of taxation. No new power created or conferred, but simply prohibited the previous complete and plenary power of income taxation possessed by Congress from the beginning from being taken out of the category of indirect taxation to which it inherently belonged. So in Brushaber, they reject the contention that it's a new power to tax directly. And in Stanton, they repeat, they reiterate, not creating a direct tax. It is prohibited from being taken out of the category of indirect taxation to which it inherently belongs. And they go on. We are of opinion, however, that the confusion is not inherent, but rather rises from the conclusion that the 16th Amendment provides for a hitherto unknown power of taxation, that is, a power to levy an income tax, which, although direct, should not be subject to the regulation of apportionment applicable to all other direct taxes. And here's the key. And the far-reaching effect of this erroneous assumption will be made clear by analyzing the arguments, paraphrasing. The far-reaching effect of this erroneous assumption. It's an erroneous assumption that the 16th Amendment provides for a hitherto unknown power of taxation. This is as plain and clear as it gets from the Supreme Court. God knows what the IRS, the DOJ, and the lower federal courts have been doing for 100 years. God only knows. Oh, I know, and we'll get to it later. It clearly results that the proposition, i.e., if we let them tax directly and without apportionment, it clearly results that the proposition and the contentions under it, if acceded to, would cause one provision of the Constitution to destroy another. That is, they would result in bringing the provisions of the amendment exempting a direct tax from apportionment into irreconcilable conflict with the general requirement that all direct taxes be apportioned. This result would create radical and destructive changes in our constitutional system and multiply confusion. Oh, you mean like introducing the enforcement of the second plank of the Communist Manifesto instead of constitutional taxation by enforcing income tax as though it were a direct tax without limitation? Yeah, that's exactly what they mean. You mean you didn't know that the second plank of the Communist Manifesto is a heavy, progressive, or graduated income tax? That's where you find taxation of the labors of the people. That's where you find ruling the people through controlling their labor. That's where you find class warfare through non-uniform, unconstitutional, graduated taxation that breaks the American people into different classes and then sets them into a system of class warfare, where the citizens, instead of being represented by the government, are constantly calling from both sides for the government to step in and settle the class warfare, violence, and conflict consuming the population. And of course, it's the politicians who created the class warfare and who are profiting from it, because by keeping the American people waging war against one another, they somehow failed to notice that it's the political class that's looting the treasury, running the currency out, destroying the fate of the nation and our children and our grandchildren. We don't have a system of constitutional taxation anymore. Okay, let's look at what the Treasury said. Right after the Bershaber decision was released, upholding the constitutionality of the tax as a system of collection of the tax at the source, where the duty to pay the tax is given to corporations with the duty to retain and pay, which is we're going to see is a system of withholding. And isn't it interesting that they did exactly the same thing 32 years later in 1945 when they finally did get around to implementing employment taxes? Indirect collection at the source. The employer deducts and withholds and has the duty to retain and pay. Okay, so Treasury Decision 2313 back in the early 1900s. Treasury decisions are how the agency, the Treasury Department, reacted to Supreme Court decisions in order to instruct and other things. New laws, for example, how they reacted to new laws, new rulings in order to instruct their department employees, everybody in the agency, on how to handle the new decision in their interaction with the American public. So, Treasury Decision 2313, income tax, addressing the taxability of interest from bonds and dividends on stock of domestic corporations owned by non-resident aliens, and the liabilities of non-resident aliens. What's going on? Treasury Department, March 21, 1960. Let's see what they say. To collectors of internal revenue. Oh, collectors. You mean it's not victims or subjects? It's collectors? Under the decision of the Supreme Court of the United States in the case of Bershaber v. Union Pacific Railway Company, decided January 21, 1916, it is hereby held that income accruing to non-resident aliens in the form of interest from the bonds and dividends on the stock of domestic corporations is subject to the income tax imposed by the Act of October 3rd, 1913. Non-resident alien, not citizens. The next paragraph. Who is subject? Non-resident aliens. Who is liable? Non-resident aliens are not entitled to the specific exemption designated in paragraph C of the income tax law. That must be an exemption for citizens, huh? And they're not entitled to it, the non-resident aliens. What they are liable for the normal and additional tax upon the entire net income from all property owned and of every business, trade, or profession carried on in the United States. Non-resident aliens are subject, non-resident aliens are liable. Oh, and look, the responsible heads, agents, or representatives of non-resident aliens, come back, who are in charge of the property owned or the business carried on within the United States shall make a full and complete return of the income therefrom on Form 1040. What? Agents of non-resident aliens make a return of the income earned by the non-resident alien on a Form 1040? Don't report their own income? You mean the 1040 was a withholding return? Yeah. That's what I mean. Tax was only imposed on non-resident aliens. They were the only persons liable for the tax. And we're going to see why the Treasury had to say they're liable in the Treasury decision, because the statutes don't actually make them liable. Well, we're going to look at the statutes in just a minute. And then the collectors, the tax collectors who withhold money from non-resident aliens, make a report of everything they withhold on the Form 1040 return relating to the money collected from the non-resident alien. A 1040 was originally used the way a 1099 is used today, or a W-2 is used today. 1040 was the original reporting of earnings collected. or earnings earned and collected, just like on a 1099 or W-2. Originally, the function of the 1040 was to do that. That function got changed at the end of World War II, when they switched the Form 1040 to being a reporting of earnings mechanism to a file for a refund mechanism. Okay, now let's look at the law. Well, what we saw is that the Supreme Court said the Act provides for collecting the tax at the source through the duty of the corporations, etc., to retain and pay the sum of the tax. Well, look, what do you know? Here we are, section 7701A. This is the same section where the term person is defined at A1 for use throughout the title. The definitions provided here in this 7701A section are used throughout the title. And let's see what we can find. A16, withholding agent. That sounds like he might be a tax collector. The term withholding agent means any person required to deduct and withhold any tax under the provisions of sections 1441, 1442, 1443, 1461. Deduct and withhold. Is that the duty to retain that the Supreme Court referenced? I believe it is. And you remember that there was no tax on employment in 1913. This is the class of tax collectors they created to administer the provisions of the income tax. And the only section cited is the authority of the collector, the withholding agent, to operate. But right here, 1441, withholding of tax on non-resident aliens. Oh, a little farther, what happened? Bring it back, bring it back. 1442, withholding of tax on foreign corporations. 1443, withholding of tax on foreign tax exempt organizations. 1461, liability for withheld tax. Every person required to deduct and withhold. Now remember, a person under A1 is any corporation, trust, institution. Remember, corporations, etc., with the duty to retain and pay. The withholding agents are corporations, persons, individuals, trust, any entity that makes a payment to a non-resident alien is made the withholding agent and is required to collect tax by deducting and withholding money from payments made to non-resident aliens. And then under 1461, every person required to deduct and withhold any tax under this chapter is hereby made liable for such tax and is hereby indemnified against the claims and demands of any person for the amount of any payments made in accordance with the provisions of this chapter. It's the tax collectors who were made liable for the tax, not the individual earners. We're going to tie up this section 1 here, and we'll show you more on section 2. Okay, we got the second part here coming up in a bit. I've got to take a break right now. I'll get back to this in just a moment with part 2. So this will be labeled as part 1 on the videos. Very good. Thomas Freed, tax-freedom.com. All the information is there. All you need to do is start reading to become informed, enlightened, and freed. There you go.